partner of the real estate division at Diamond & Diamond. There's a whole bunch of us. Ed's one of our senior lawyers who's kind of a surprise guest today. So he just lives down the street, so he said he'd pop by too, which is awesome. So I'm going to go through what happens when a deal doesn't close, more on the legal side a little bit. Just the idea being to give you guys a bit of a baseline understanding when you're talking to your clients and they're in that stressful situation where, God forbid they're the buyer and they didn't get their mortgage or whatever. Sucks for you because you're in a situation that's not really
commission.
Pardon?
No commission.
No commission, right? You did all this work. You set everything up. Everything's good to go. They told you they can afford the place, and now they can't, right? And that's tough. And it's probably coming to you a little bit. They're obviously coming to us as well. We're in your boat too. Like, we usually get paid when the deal closes. It's a lot harder getting paid when the deal's not closing, but we all get sucked into this together, I think. So,
but are you getting the retainer? Because unlike some lawyers, they ask for a retainer, and this will stay regardless, whether it's closed or not.
That would be nice, but no. At Diamond, we try not to ask for people's money up front. Only in certain civil litigation scenarios. And of course, with the real estate, we don't expect it to turn into civil litigation. Usually it doesn't. So we try not to take any money from people until their deal's closing. So we ask for people to drop off one check, usually 2 days or so before the deal closes, and that'll be enough money to pay everything, including us, thankfully. So that's kind of how that works. But what we'll talk about today is when it doesn't work, of course, and it's a nightmare scenario for everyone involved. But thinking a little bit, not just for the buyers, but also for your seller clients, because in a lot of ways, you're probably going to end up relisting the home for the seller client, right, when they have a buyer who defaults on them. So it still sucks. You're not getting paid right now, but you're probably going to get paid later, and you probably don't want to lose the client. It's not really their fault that the buyer can't close, all that type of stuff, right? So you're going to be dealing with them probably for a little while, probably relisting their home, all that fun stuff. So we'll talk about that a little bit today. Click the button there, and we'll see it. I'll also say, I'm going to go over this kind of quickly. If you want me to slow down, or if there's anything interesting you want me to stop at, just speak up, interrupt me as much as you want, guys. But I'm going to try to go fast because Ed's here today. I thought it would also be kind of fun at the end. We'll spend a little bit of time talking about some recent fights we're in, some recent scenarios we've seen this summer, because it's a little bit nastier this summer than it's been in summers previous. Okay, so we'll talk about that. Okay, so resale deals. That's mostly what we're going to focus on today. That's the bulk of where these issues arise. And what is that in opposing to? That's opposing to like builder deals, which we're not really going to talk too much about today. They kind of work a little differently. As you probably know, a deposit is usually put into the listing brokerage trust account. And there's 3 ways that deposit can be brought out of the trust account, according to RICO, right? The successful closing of the deal, that's too bad in this situation. Assigned and mutual direction, not a release necessarily, but assigned and mutual direction provided to the brokerage from both parties, buyer and seller, or court order. So pretty limited options.
Which the mutual is actually the language contains its own direction within the OREA form.
Yeah.
In the act.
Yeah, so you can do the OREA form. Doesn't have to be, is all I mean, but those are pretty limited options to get the money out. So the question we always get from the buyer is, how do I get my deposit back? And because I still need to buy something. Like, I didn't buy this now. I still have to go buy it. I need to live somewhere. And sellers are usually asking us, well, I need this money for my purchase. I'm buying something with the sale money, of course. So they're usually not planning to go rent. That's pretty rare. And I can't actually afford to carry 2 properties. So how am I going to deal with that? So that's what they come crying to us about. So focus on the buyer for a little bit. Court of Appeal said that where the vendor suffers no loss, the vendor may nevertheless retain the deposit subject to relief from forfeiture. So that happened in 2019. That case was a result of, if you guys have been around for a little while, in 2017 we had a similar summer where there was a lot of nastiness going on. And a whole bunch of cases kind of came out, and that was interesting because it's been a long time at that point since we really had the problem of prices actually decreasing in significant amounts, like in a month, right? So lots of cases went to court, and Court of Appeal said, nope, law hasn't changed. You get the deposit no matter what if your buyer has failed, okay? I probably shouldn't say no matter what. There's obviously some caveats there, but by and large, that's generally how the court will treat it. Oh yeah, okay, I guess that's highlight for us. Okay. Cool. So the seller, they still want their money. They wanted to buy their house. They still want to buy their house, and they're locked into a deal too, right? So they can't become the defaulting buyer on their side. Their obligation in a lot of ways is try to avoid default as much as they possibly can on their own deal. So that oftentimes means getting some crappy loans. They're holding on to their sale property now because the buyer has failed. We're probably in a situation where we need extensions, unfortunately, on their own purchase. So there's going to be probably some costs associated with that extension. We're also in a scenario where they're scrambling to find enough money because now they're not getting their $400,000 in their pocket that they're expecting, right? So we try to help people with some solutions there. Our Dime Real Estate Department is, kind of segregated into two groupings at the firm. So we have our, buy, sell, refinance grouping, and then we have our private lending grouping. The nice part of that is when we have these scenarios, we walk over across the aisle and talk to the private loan lending guys and say, look, can you find someone who's reasonable who can shoot these guys a short-term loan to get them not to fail on their next deal? If you have any experience with private mortgages, it's not cheap, right? They gouge quite a bit up front, typically, and they're usually like 10% plus, to try to do that type of thing. So they might have to marry one of those with a bridge, or they have to marry one of those with refinancing the property. It's going to take time, so they probably need a bit of an extension no matter what. Good news for the sellers, though, is it's worthwhile. Because they're not going to get sucked into another lawsuit, which if they do end up defaulting, there's obviously remedies that they can try to pass that off to their original breacher, the original buyer. And you can end up with lawsuits that are kind of dominoes like that. But if at all possible, it's in their interest, at least in my opinion, to try to stop that domino chain because they get to move into the house they want, and that's probably their primary objective. Right? So if they move into the house they want, then they have a right against their breaching buyer for basically, 1 minus 2 here. One is all their costs, okay? So if they're supposed to buy for $1 million, sell for $1 million, buyer breaches, they go back out on today's market, they signed the deal back in March or something, they come back on today's market, they only get $800,000. It's a $200,000 loss. It's going to be hard to stomach. Good news is they're entitled to that $200,000, but they're also entitled to the costs of carrying, which is going to be significant in our example because there's private mortgaging going on. That's going to be it's going to be in the tens of thousands of dollars in costs. There's going to be the cost of carrying the existing mortgage for a longer period of time, and maybe they need a bridge loan on top of that. And there's also utilities, taxes, etc. As you can tell, when we're in the litigation scenario on the buyer side, the seller side, I keep doing that, seller side. We kind of start racking up the bill. The bill keeps getting bigger and bigger and bigger. And that's, unfortunately for the buyer, that's just kind of the way it is. These are all legitimate costs the seller has faced because the buyer was not able to close on the deal they promised they could close. So, but number 3 down there says that, or the amount of the deposit if it's greater. So if you remember what the Court of Appeal said, you get the deposit. Okay, so if the deposit is $30,000, and somehow they manage to resell for the $1 million, maybe they even make a profit. We're dealing with a bunch of those scenarios right now too, where they've actually made money. It doesn't matter. We're probably still suing the seller, or buyer, still suing the buyer for that $30,000 deposit or the trust account. Because, it's at the end of the day, most of our clients, they still want that money because they feel they're entitled to it because they went through all the headache and wasted time and all that stuff of getting it relisted. In fact, they sold for more. They're not feeling too generous about the person who caused all that to the buyer. So costs incurred. When I talk about racking up the bill there, what we're talking about here is it's really then becomes up to that seller to be very careful in how they proceed from the point of breach onward. So that is, you guys as real estate agents, your job in that scenario is you want to push that off to the lawyer as much as possible. There's no reason for you guys to take on any liability there whatsoever. You don't want to get called in a lawsuit, any of that stuff. If the client's coming to you, oh, can I relist now? Can I do this? Can I sell it to my best friend for this amount of money or whatever? Go talk to your lawyer. I know they want you to give them an answer. Try not to give them an answer. I know it's tough, but try to push that off because that's a scenario where this is probably already going to court. So you're kind of on the record already. You're kind of at risk of getting drawn into things, much more so than a regular deal where you can kind of give some off-the-cuff advice, maybe unwritten advice that we all know, we all do, right? But this you want to be a lot more careful, obviously. This is going to end up in court, and even if the other side doesn't defend, we'll talk about at the end. Back in 2017, we had when all that was going on, we had a scenario where our client was owed about $270,000 because of the breach. Okay, so breach happened, failed to get even close to the same price on relist. Had to do the private lending thing. It was kind of like everything went wrong for this guy that possibly could go wrong. We were working for the seller, so we ended up going to court. The buyer didn't even try to defend. The buyer was like, I screwed up. I'm not wasting more money on a lawyer. Whatever happens, happens. They put zero effort into the defense. But the judge still grilled us on the lawsuit, grilled us on every single item, and wanted to know why did this happen? Why did that happen? Show me a receipt for this. Show me a receipt for that. And ended up throwing out a bunch of our client's claims because our client didn't have very good evidence of actually paying this thing, these amounts. And my client, to be honest, in that not all my clients are, but that was a very honest client. He didn't really have any interest. He's a pretty well-off guy. He didn't really have any interest in nickel and diming for every little thing. So he just was more an oversight rather than someone trying to, grab every penny they could. But still, because he hadn't been keeping very good records, judge wasn't very impressed with his record keeping in certain areas. He only got the $270,000 instead of the $280,000 or whatever we were trying to get. So, that's a bit of off-the-cuff advice you can give them, I think, which is a good idea. Is look, you need to talk to the lawyer about any sort of actions you're trying to take regarding like when you can relist. But when you are relisting and before you relist, be documenting everything, making sure you're keeping all your receipts. And also probably good idea to exchange an email as to why you take an action you do. Right? It's all good and well to have a phone call saying, oh, this is the best offer on the table for these reasons. Let's take this. Cool. Probably send that in an email, right? Because the judge is going to look at why did you pick this offer over the other one? Or they might not, but they might. And your client or their lawyer is going to be asked to defend that decision. And why should I award, this amount of money and not a lesser amount because there was multiple deals coming in and you picked this one? Have some sort of a defense. If it's in email form, some writing between you and your client, it's probably helping your client a little bit. Okay, so something to think about. There's also the clean hands principle at court. Again, you don't need to be advising on this, but it's something maybe to know of in the back of your head, because I, at least in my years, I've seen it many, many times where you end up with a seller who now has a buyer more or less at their mercy, and they're thinking, well, I'm going to find a way to sell this to my buddy or something like that, or get a even bigger quantum of damage, and my buddy will later on do some favor back to me or something, some sort of quid pro quo. There's a clean hands principle at court as well as other duties that sellers have, but the clean hands principle is generally judges don't like to help people if they show up at court without clean hands. That's all it really is. And they'll put that right in their decision. So, fairly, I think this is a recent one. Yeah, this happened last month. A judge said that this defendant, in this case, it was actually the opposite. It was the buyer was trying to wiggle out of something, but they hadn't really done any attempts whatsoever, and they kind of been lying all the way along. And the judge said, look, he's not entitled to any relief. He hasn't showed up to court with clean hands. Like, I'm not wasting my time with this guy. Pretty much what the judge needs. So I don't know how good his rest of his defense was. I haven't really read this case in particular. But the fact that he came out and said this just shows me that the judge didn't like this guy, didn't like his conduct, wasn't interested in whatever legal technical arguments he might have had. He showed up probably either with a lot of fraud or a lot of lies or a lot of stuff attached to him. So he was out of luck asking the judge for help. Okay, so what about when the seller breaches? So the seller breaches are tough because it's almost as bad for the buyer as far as like an emotional and their time is concerned. You know, they were expecting to move in, and the seller says, "Yeah, I'm not selling this place for X, Y, Z reason, or no reason whatsoever. I'm not going to close with you." We've had that a few times where it just won't close, and no one. And when you're on the buying side, you have no idea why, and you as the agent probably have some guesses. Prices are going up, you know, or something's changed, you know, in the seller's life or whatever. They just refuse to close. It's tough for buyers to collect through the court. Mostly because of this, my honest opinion is just the startup costs to get it going. You're like betting at the casino when you're the buyer. Like you have to put money in, right? You're going to hire some litigator. You probably want like $5,000 to get the case started. So you're putting $5,000 in, thinking you're going to get some money back, but the litigator will tell you, "I have no idea how much you're going to get." Like the litigators tend to not have a good idea how much they're entitled to, unless there's something very specific and quantifiable they can point to. So the case that we cite there is a case where it's quite an old one actually, 1975. It's a case where a buyer actually won an $88,000 award because in that case he had bought and then he had assigned, and then the seller refused, and he was expecting 88 or 90,000 in profit, and the judge said, "Well, here I have a clear amount of damage to award, so we can award an actual price." That's the beautiful type of case where there's a clear number. That's almost never going to happen. But what the judge is supposed to be looking for is like, what is the actual loss here? And in a declining market, there's no loss. So you're tough. The only other remedy to look for is specific performance, where a judge would order the transaction take place. That's what Elon Musk is trying to avoid down south there. So at least in real estate, in the last decade or so, it's become pretty difficult to get specific performance in real estate transactions. So we won't spend too much time on that today at all, but it's an unreliable way to go. And again, I view every court action as a gambling exercise. That's just how my mind works. You put $5,000 down, what's the percentage chance you're going to get at least that $5,000 back? What's the chance it's actually going to end up being a $10,000 charge for you to go all the way? And specific performance is usually a bad bet unless you have some really good reasons. Okay, so what can we do about this as advisors to people who are buying and selling, real estate? There's some that I'm sure you guys know that are kind of obvious. Work for the buyer. You want to kind of put as low of a deposit down as you can, because that's setting the minimum amount of damage that they could ever have, especially if they're buyers who you got a feeling are kind of stretching their means a little bit. If you can, I know you can't always, it depends on the market and all that. You're trying to lower their deposit where possible, limit their liability. Sellers, it's very much the opposite. It is worth going after a deposit. It is not usually worth going after $10,000 in the bill of other stuff I was talking about. So if there's only a $10,000 deposit, let's say, and they actually cost them $18,000, $19,000, $20,000 due to the buyer's breach, the client is probably going to end up in a situation where they're getting some advice by the lawyer. Do you want to just go after the deposit? It's going to be a lot faster, a lot cheaper. You're kind of giving up on a bunch of other items, but those other items are going to be more contentious. The judge is going to look at them much, more thoroughly. We have a lot more work to prove all those items. Depending on, how much it is, it might actually cause the change from small claims court into superior court. That's actually a fairly common problem. Is if it's a $35,000 deposit, client thinks they're entitled to $55,000 or whatever. Let's not go for everything. Let's try to keep it in small claims. It's going to save you a bunch of legal costs and a bunch of time staying in the superior court. So, but hey, if the deposit was $50,000, we'll go after the deposit 100%. It's worth it. So it won't take that much time.
You also can't recover all of your legal fees too, which is another big part of the calculation too.
Mm-hmm. Yeah, that's a good point. So
you can or you can't?
You can't. All of them. Okay.
yeah, so the if Small claims court has a very limited amount of legal fees you can recover. Like sometimes you see like just hilarious amounts, like only like $300 towards your legal costs or something like that. It's not helping anyone. And in a deposit scenario, to be honest, we like in a small claim, I have one small claims right now. We're not even going to try to get costs because like it's not worth it. If you get like even if I get $1,000 cost award, all I want is the deposit. We're not going to then spend time chasing this guy for $1,000 for the next 2 years. So like the cost award is a joke. So that's an issue. And then yes, Superior becomes quite a bit more expensive for lawyer costs than small claims. Okay, so back to what can we do is buyers who know they're going to breach. This happens sometimes. We've seen this quite a bit. And Ed, probably more so than I this summer. Ed's been at a string of bad luck with a bunch of buyers who know they can't do it, and it's like a month away from closing, and they bought, and the interest rates all changed, and now their mortgage broker's coming to them saying like you're dreaming. Like, we have no chance to get enough money for this. And so assuming they can't run around to family and find a way out of it or whatever, it's usually, these days it's been quite a bit of money. It's best to get on that ASAP. In our experience, buyers tend to end up in a better situation if that is sorted out pre-closing than post-closing. And that's just simply because you have probably a more amenable seller. After you've breached, sellers are kind of pissed off usually. They're in a bad situation. So, and honestly, when I'm working for buyers at all, we're intentionally dragging our feet usually after that because I just want the seller to cool off. Once they found a new place and they moved in and they've kind of forgotten about it a little bit. They're probably still mad. I'm not going to get rid of the anger, but the rage is hopefully gone at that point. So it slows everything down, and that's not great for the buyer because the buyer needs resolution to this too. They need to get something out of the deal, hopefully. But we have much better success before than after, I would say. Would you agree with that, Ed?
Yeah, I think too. It's early on. There's two schools of thought. One of them is wait to the last minute to kind of put the seller in a corner and force them to make a decision. And the less time they have to think about what they can charge the buyer, the better for the buyer. But that just makes them really angry. And so they could, depending on the seller that you get, could completely mess up the buyer with like the amount of fees and things. Like I've seen, just some random fees for no reason, just like $10,000, and for what? Okay, but just because.
Yeah.
And it's like, well, now I know you can charge that, but like, there's got to be a reason behind it. It's like, well, you're a pain in the butt, so I'm charging you $10,000. So sometimes it's actually better to do it early on. This way, there's time to negotiate. And we'll kind of go through some examples. Some things that I've done is like allowing the seller to relist the property in the meantime to see what happens, and let the buyer at the same time figure out their mortgage financing situation, which is usually to provide financing at that point. But there's like things that we do that we kind of try and negotiate. And I find the conversations typically go a little bit better when it's early on than last minute. But it just depends on the strategy you're trying to go for with the seller.
And though might not be like a strictly legal, like technical reason for this, I do think it probably helps a bit if it does end up in litigation. Like the buyer, if we're going to end up with the defense, is going to be, hey, I told you 3 weeks before closing that I couldn't do this. I know that I didn't like repudiate the agreement. I don't have the right to do that and all that type of stuff. But you had 3 weeks to like figure this out. It's not like I dropped this on you last minute. All that stuff. I remember a long time ago one of my law school professors saying, judges have pants, which just means like they're people too. They hear that and they're like, okay, this guy's not entirely the problem. He was acting reasonably. And my 2 cents is judges are usually just trying to find out who's acting reasonably and who's not. The fact that he couldn't close is an unfortunate fact, but if he's at least acting reasonably, going back to that clean hands principle, he's showing up with very clean hands, judges probably more likely to benefit of the doubt when they have wiggle room. And there's lots of times judges have wiggle room between, what they do or what they don't award. So it helps, I think, in an unseen way more often than not. Why click the next one? There's also some notes there about bad mortgages, which I kind of talked about. But at the end of the day, knowing how bad things can be for buyers if they default means, you know, if they have to take a really bad private mortgage, sometimes that makes sense. And we'll try to walk them through with that. And again, that's one of those areas, that's probably where you want to limit your advice and say, look, you need to sit with your mortgage broker. Don't take on the mortgage broker's liability. This is their problem, not your problem. But still, sit down with the mortgage broker, think about how bad this could be, and think about what is the cost of this bad, terrible mortgage they've drummed up for you at the last minute, right? And all you can really do is try to help them with how bad can it be, that part of the question. Because you can say, look, this market's gone down. So you agreed to buy for 900. You know, things have changed in the last 3 months since we signed, or 2 months since we signed. You know, it's probably only going for 850 now or something. I don't know, right? Whatever you guys kind of think, you're if nothing else, we need to try to help our clients make a more rational decision and get past. Unfortunately, there's a lot of denial in them. There's probably a lot of hope that things will somehow work out before the end, and they may, but that's not a good bet. Again, this is all a game at the casino, and it's, you know, where you're going to place your bets. Don't bet on the last minute savior coming in. Start acting rationally early as fast as you can.
I think also too, buyers and sellers, and for most part, you know, these aren't people that sell every other year or every 2 years. Most people hold on to these properties for 10 years. Now, they haven't done something like this in 10 years. They don't know what mortgage approvals mean or pre-approvals are. Like, you know, when a mortgage broker gives them an approval letter, it just means that based on their income that they told them they're qualified for this home, but they haven't done appraisals yet. They haven't actually verified their income. They haven't verified where the deposit came from, or any of these other things. All that stuff comes after. And so you're already in a firm and binding deal, and then the broker tells you, well, you know what, based on everything, based on our due diligence now, we can't really give you the mortgage anymore, and you can only qualify for this. So having clients that have a little bit of wiggle room, movement in terms of equity that they can put down extra, I think is always a better bet for a buyer, especially in this market right now too, where prices are coming down, or they're not really unsure what the price is. You know, before, up until now, we knew that it didn't matter what the price was. You're going to qualify for the mortgage. The appraisal is going to come back fine. Now we've got appraisals we're dealing with and all kinds of other stuff, right? So having a client that can definitely spread themselves a little bit is better in that scenario to avoid all this, basically, right? So
Yeah, like if you take one thing away from all that, is like there was zero winners in any of that, right? Other than maybe Diamond or the other lawyers involved, they make money. But
I find the litigation lawyers actually are the ones that,
Yeah.
that get everything.
they're the
because-
only ones who win in this.
Yeah.
The seller's losing, even though they're recovering. You know, I talked about that one case with the big award back in 2017. That was great for us to win, and it was great for the legal fees of the litigator. The client didn't actually end up getting much of that money for 2 years after we won. It took a long time. COVID made it a lot worse. We had a sheriff. They were about to seize the property, and then COVID hit, and the sheriff's office closed. And you know, and the sheriff's office didn't open up again until whatever it was, 6 months ago or something like that. So yeah, that usually isn't that bad, but still, he didn't win. This is all, even though he got that big amount of money, he was supposed to get at least that before anyway. So if the deal had closed, he's in a much better scenario, and he wouldn't have had to pay litigator fees. So.
I think Mike also mentioned one of the things was mitigating your damages, trying to mitigate before, like you're now in this deal, you've got your damages, everyone knows, okay, we're going to suffer $100,000 of damages, deposit's only 30. So we know that the difference there, 70,000, is what we can actually sue for, because remember, you only get up to, you can get the damages out of the deposit itself, right? But, so you now win your case, you know, you sue, you pay $20,000, $30,000 to a lawyer, you win your case, you got a piece of paper that says, now I won, and you buyer owe me $70K. Well, trying to collect that $70K is also another problem now, because if that buyer doesn't have any money, maybe they're a first-time home buyer, maybe they already sold their other property. It's hard to trail any assets to try and lien them in any way. So now you're stuck with this piece of paper that says, I won, and you owe me money, and now there's no buyer that can you actually collect from. right? So mitigating your damages in advance and trying to decide, okay, well, I'm going to spend, you know, $30,000 on legal fees, or I can collect $50,000 from this guy.
it was a seller default, and we're working for the seller. The deposit's $35,000, and the offer to the buyer is $5,000, like $5,000 to sign the direction and walk, right? So buyers aren't out to lunch. They can get something back. They need to use their only real leverage in that scenario against us is, hey, if you don't take our offer, you got to go through the court process. It's going to take some time. They know the deposit will be released. They know it's going to end up, not in their favor. But hey, do you just want to get some money now? That can be fairly powerful, especially, when the alternative is you got to deal with a bunch of damn lawyers for a while. So buyers aren't completely screwed. They're not in a good spot though.
Yeah, I mean, I had a scenario recently. So we were acting for a seller. His total damages that he was able to calculate was about 200 and something. I forgot the exact amount. So 250,000, I think. It was 250. And instead of going through the whole circus of the courts and trying to figure out who owes what and all that sort of stuff, we ended up negotiating. I think it was 180,000 in total, or 170,000 total for him that the buyer ended up paying, including their deposit. So they had an $80,000 deposit and they gave an additional 100,000 on top of that, and signed a mutual release. He got his 180,000. I think he's still keeping the property actually, and decided to rent it out instead. So
much for the real estate agent.
But that was one example.
And what was the damage because of the 180,000?
The difference in the sale price,
Ah.
plus debts that he had that he wanted to pay off, that were basically forcing him to sell the property. He was forced to sell the property because of debts that he had. Is what he told me, at least. I don't know if that's actually true or not, but
But that's a good point to take a brief pause and talk about. One of the problems is that as the buyer, you can't reasonably know the damages beyond the difference in price. So that's all you can really help them with as the agent. Like, that property would probably go for roughly this amount at this point in time, or the next month. That's how I see it going, or whatever. But that's not the end of the story. So like Ed's talking about, when you're buying from someone that's, got 3 mortgages on their house, the damages are a lot worse than the guy who's got the house paid off, because you don't close on the guy selling the house. He was expecting that money with a right to pay off all his mortgages and get himself cleaned up, right? Now he can't. So now these mortgage companies, a guy with 3 mortgages who doesn't sell is probably facing foreclosure, to be honest with you. So it's going to get nasty. And as a buyer, is that fair? No. Right? Like, why is it, most people will say no. They'll think no. They'll say, I was just trying to buy this house. Why am I now getting dragged into all this guy's costs or whatever, right? But unfortunately, you kind of do. The seller has a right to be put back in a position, more or less, of what would their financial kind of balance sheet look like if the deal had closed. And it would have been a lot better had it closed than if it didn't when you have 3 mortgages. So, again, just to lump on the scariness of not closing as a buyer, that's another thing to think about.
What are some of the elements?
Quick question for you
for
guys.
sure.
Who is the responsibility on? Is it the buyer or the seller to get the deposit back? So if the buyer backs out and there's hypothetically like $35,000 deposit, is it the buyer that's trying to get the deposit back? Is he the first to act, or is it the seller that's saying, well, you're not getting this back? Because there is a release of that deposit that something has to be signed, right?
Yeah, but it depends on who's entitled to it is probably the right answer, right? Like, if the buyer defaulted, they're not in any rush to get that deposit released for the benefit of the seller, because the seller's going to probably end up getting it back. If the seller defaulted, it's kind of the vice versa, right? Like, the buyer's going to be the one getting that deposit back. The seller's probably not in any rush to help them. They should be. It's kind of mean of them not to be, but they don't have to. So, that's the long answer. The short answer is no one, right? It's not anyone's obligation to get it started, so it needs to be someone with an interest. If the brokerage is holding the money, I think it's a year, after a year where the brokerage kind of knows who's supposed to get the money, they have to submit it to RICO. If it's 2 years if they're not sure. I think most brokerages do it after a year to be safe, to be honest with you.
One of the questions I had actually was, when you're in the middle of negotiation, there's multiple offers, and let's say you representing the buyer in this situation, you won the bid, and it was a clean offer, but the next day the guy wakes up and doesn't want to give a deposit. He wants to get out. So what are as a buyer agent, what are the repercussions there? And then on the seller side, what are my options?
Seller side is tough, to be honest. Like, you have to kind of puff your chest. Probably want to put in writing that you grant them an extension to get the deposit in and set a hard timeline. The agreement itself, like your basic array agreement, kind of puts in a hard timeline, but I've never actually been involved in a case where we had to fight over this, but the cases I know about, the sellers ended up being more successful on the relist when they said, you know, okay, we'll give you another 48 hours. After 48 hours, the agreement's terminated, like you're gone, and we're going to relist. And in today's market, that's not ideal because you might be relisting with a worse price or something like that. But again, going back to mitigation, I think you got to do it, and you got to get someone in ASAP and get the deposit. You don't want to be kind of bumbling around saying, well, now I'm losing $10,000, I'm going to sue you, and letting that drag on for weeks. I just don't think it's going to go.
Let's say we do the deal on a Monday night, and Tuesday we find out the deposit's not coming, and we're representing the seller. Can we start chasing the buyer, or send them a legal notice, but at the same time try to sell it? And in the event that we don't sell it, do we have grounds to?
I think you've got to set yourself a direction, one or the other.
You can't do both because I'm trying to sell it to litigate.
Because you're still in a deal that's still firm and binding.
Correct.
Right? And technically speaking, even though they didn't give you the deposits, the only thing that you can do is pursue them for breach of contract.
Okay.
That's all it is, right? So you can potentially even start a specific performance.
Yeah, again,
I don't think it's
worth it.
Because I would try to relist it and do what I
Try
gotta
to
do,
relist,
right?
but-
But in the meantime, you know, your client wants to see you do something about it.
Yeah, I think what your explanation to the client is, I know that the agent called me and said we're not, like, you might get a call saying we're not giving a deposit, right? It might be as clear as day to you or whatever.
Yeah.
But still, in writing, saying if we don't have the deposit by X hour, X day, we're relisting the property and the agreement is null and void. In the meantime, like, if you're kind of behind the scenes talking to people who had submitted the offer before, saying, hey, we're going to be looking at your offer again tomorrow at noon when this dies or whatever, that's proactive. I don't think you're going to get in trouble for that at all.
As long as we're not an actual
As a
deal.
brokerage, and we speak from the brokerage side.
Yeah, for sure.
We would require mutual release and no deposit received. So releasing both parties from their contractual obligations.
Yeah.
And then you can go ahead and do whatever you want.
I'm just thinking of how to hold them responsible because we are starting to see when the market's hot, a lot of buyers, even they ask us, can we put 3 offers in one place?
But you still have a contract in place.
Yeah, right? But then we go through that work, they put in the offer and you get them the deal and then they back out, right?
Yeah.
So how do you hold people
But you
responsible?
have to be careful because I remember one of the first courses was like, you cannot play tennis on 2 courts at the same time.
Yeah.
Which is-
so like if you're acting, you know, if you just now dealing with the other party, because that's what Carole said, you have to get the best is to get a release of official kind of on
Yeah, you can't
paper,
have 2 deals.
because you are still obliged to the first deal.
Correct, so
Right?
which we don't put. We don't put the 2 offer, but what I'm saying is,
I think from the
Yeah.
seller side, like what
Well,
sort
except maybe it's a
of,
different
what can we do to, you know, because I think right now in the
Make
real
your
estate
offer
market, even when people have buyer representation agreements, they don't hold to it. The guy's gonna stop answering your phone. There's no more fear in the market. There is no more repercussion, you know? Like if you're doing this, nobody's doing anything about it. So what can we do to make a difference? I think we need to hold people a little bit more accountable. So is there anything we can do on our end? Because now you sold a property, you know, it's a ripple effect because your buyer seller or your seller bought something else. Their seller bought something else, right? But nobody, and this one guy does something funky like that and it just, right? But there's no repercussion. There is no.
Well, the repercussion is that you can pursue them for your breach in contract, for not.
But in the meantime, can I still list it and tell them
Once
that
you
they're
have your
breach?
mutual release.
But I can't do
Not
both.
if you have a
Okay.
release.
Or you can relist, and if you get another offer, to make it conditional of being released for a previous offer.
Okay.
Because you can't sell it twice.
but
That's
what about the
bottom line.
gap? Can you
What
chase the
about
gap?
if his scenario that you get the offer, they don't bring the deposit, and you were in multiple offers, you relist it, and that next offer that you you relist it, and the next offer is not as high as the one that you accepted, that they
Yeah.
didn't bring the deposit.
So, like,
But the buyer
if
gotta
you
wait.
sign the mutual
Lose
release,
buyer
you're
gotta
kind of out of luck. Like, that's the whole point of mutual release, is no one gets to sue anyone. So, like, I don't want to speak, the brokerage is gonna want you to get a mutual release just to stop any potential liability, which is gonna hurt, like, that does kind of take that option away from your client. But to be frank, I think it's just I think it's just something that's better to live with than to try to go down the litigation route, to try to hold people responsible. Like,
It's gonna
I
cost a lot of money.
completely, am for the sentiment, but we're stuck in this game, and again, taking a step back and trying to pull the emotion out of it and say, look, I'm at the casino, what is a good bet, what's not a good bet, and this isn't a good bet. It's better to get the client, relisted, get a new buyer in the door. And the only thing that could maybe be done, that, this is a RIA, not really you guys, but unless you end up making kind of a custom form or whatever, is just shorten the deposit timeline, or say, deposit must be received, by 10 next morning, or deals debt, right in the contract. If a RIA would do that one day.
You can do that.
Yeah, you can
alter
add
the
it to
contract.
scheduling.
Yeah,
There's
I
no
guess you
problem
could.
with that.
Especially if you're noticing it a lot, like, that's a good time to start, adding in extra provision in the schedule. It's true. So, if it's becoming a problem, then tighten the timelines on when the deposit needs to be received, or too bad, your offer's dead, we're going to the next guy.
Okay, fair enough.
Yeah.
I have a completely different question. Because most of those cases you presented was like based on some financials, market changing values, etc. What if there is a transaction, and let's say 2 weeks before closing, the buyer comes to the house, and he hears from the neighbor, because some reason talk to the neighbor, that in this place there was a latent defect, that this either seller or previous seller committed suicide on the property, and now we have a buyer who believes, he said, I am not closing the transaction because so we have just lack of disclosure, simply, yes.
Yeah.
Then be another lack of disclosure, because let's say even the buyer had a home inspection, but he comes here and he finds out that they are repairing something which was not disclosed, that they had some kind of problem with the house, or even removing a tank, oil tank from the, whatever the case may be.
Yeah.
So based on non-disclosure, is the buyer can be released from the transaction? Every case is different. I understand there's no.
Good. It's a really good question, and it's a really tough one, to be honest with you, because it's so fact based and tough to give you any kind of generic rules that can kind of guide you guys. But we actually had a really, like, last month we had a buyer file. It was another one. Ed's had that. It was an injunction the buyer filed on Ed's file, and Ed, I'll let you talk about it. But they filed basically saying, we didn't know about some aspect of the property, and we think it goes to the level that we should be released from the deal. And they got a lawyer from Palo Alto and Mississauga, a very good firm, and that lawyer was at least convinced enough that they had enough of a grounds to spend a lot of money on an emergency injunction motion, which is like the most expensive format of a lawsuit, because rather than filing and waiting for a court date and everything like that, a whole bunch of extra work has to get done by a litigator to get a court date within the next 2 weeks and get in front of a judge in an emergency session and blah blah blah. These things are like $20K just to go. So they thought, it was worth $20,000 on the bet, if you go back to my analogy.
So the scenario was, we were acting for a seller, the buyer, it all started with the listing, It all was based on information in the listing, which the realtor put in the listing saying that there's potential for a laneway development. And the buyer, it was like 3 weeks before closing, 4 weeks before closing, found out that he cannot build a laneway in the back. Because it was off by like 6 inches, and the bylaw won't allow it because it's off by 6 inches, something to do with, there's like certain dimensions and needs. And so he said, well, I only bought this property because you told me that there was potential for a laneway, and so I want out of the deal because I can't build a laneway, and my whole plan was to put my parents in there, and now I can't do that because the house is too small for all of us. And so we were like, no, it's a potential. No one said that it was going to be able to do it. Like, you have to do your own due diligence on it. That's why it's a potential. I mean, you should never use the word potential in a listing, to be honest with you.
So what's the best way to
Because
word it?
all that does is just creates like nothing but ambiguity. And you should have some sort of due diligence clause for the buyer to do their due diligence if that's what you're going to say. You make the agreement conditional, and obviously as a listing agent, you want conditional agreements, you want firm agreements, so don't use the word potential. Either you can or you can't. It's not one or the other. So anyways, they filed the action, and they used a case which was in regards to, I think it was the square footage in the property was wrong. It was like a recent case, like a year or two ago. I forgot the name of it. And the judge basically said that, the buyer was able to get released from the agreement. It was the seller's fault and the listing agent's fault that they put the wrong information on the listing. It was very specific facts, and there was one of the things that the judge was looking at as part of the test was, is this a savvy buyer or not? And the buyer at that time was a first-time home buyer, didn't know anything. The agent also went on the stand and testified that they knew that the square footage was wrong, but they still listed it that way. And so there was like a lot of bad things that happened for that case, and this case that we were dealing with obviously didn't even match the facts. This was potential, and we were dealing with a buyer that's savvy. They weren't just some regular first-time home buyer. They bought multiple times, and they didn't do their own due diligence, which they should have done. If that was the sole purpose for buying that property, was because they wanted their parents to be in this laneway development, they should have done their due diligence to make sure that they can actually do it. And they were given, I think, a survey too during the deal, which had the dimensions, which they could have easily gone to the city and been like, hey, can I go into
I
this?
think that's what they did, but they did it.
But they did it after the deal was firm, though. That was the problem. They should have put a due diligence clause in the agreement, and so the judge basically threw the case out and said, sorry, but you guys are wrong. Seller's right here, and forced them to close. They ended up, they closed.
Yep.
They did close. They were ready to close, and they even said, like, look, we're doing this because we feel we're right, we feel you're wrong, but we're also just letting you know that we will be closing on Thursday, which was like a week later. And I was like, there's no way these guys are closing on Thursday if they're suing us to tell us they're right. There's probably something in the background, they can't get financing or something, and then they get money on Thursday. I was like, oh, this is moving. I think it was Wednesday we got the judge that said, you're wrong, and Thursday we got the money and we closed. It was really weird. It was a weird scenario.
So in the comments, when we put buyer and buyer agent to verify all the measurements and information.
That was good. So that's what they did. In the agreement, there was two clauses in Schedule A and B. So B was the broker, usually the broker remarks, right, or the broker clauses, had that in there about, buyer and whatever to do their own measurements. Yeah. They make no representations in regards to zoning, bylaws, and something else, building or something like that. Yeah. And then in Schedule A, which is the one that the buyer's agent put in, he put in that clause, and he also put in something about development, like future use and development of the property, which the buyer's agent kind of messed that one up, because if they hadn't put that, if we just stuck with Schedule A, they might have had a chance, maybe not. But because there was two clauses, and one of the ones that the buyer's agent put in specifically said development and future use, it was like, I just didn't see a case there at all. The judge agreed with us, basically. But it cost our client $20-something thousand in legal fees for our law firm, and the buyer charged their client, I think, like 10 or 15,000. Our client in all of that only was able to recover 8. Right, so it was an expensive.
It's a very expensive exercise. And what you don't get to kind of see when you hear about like the result side of things, and what I think is almost more interesting is what the before. So before you get the result and what's going on, because it's a flurry of negotiation. Like Ed's spending tons and tons of time going back and forth with the other lawyers saying, we'll give you 20K off.
Yeah.
If we give you 20K off the price.
I didn't think in that one we decided that they wanted a $70,000 abatement, the purchase price, and we were like, absolutely not. Here's 15. And it was hard to get the client to even give 15, because I said, this is going to cost you guys like a solid 20 grand. Let's go with 15. see what happens. And they didn't, the other side was like, no, absolutely not, we're going to court. And
But the important part to think about is the word potential there, and the fact that that phrase was even in, eventually cost everyone a lot of money. And like, I don't think either of the agents are like gonna get in trouble in that one or anything like that, but still, sorry, go ahead.
Yeah, so I would say that, so other than the courts, the RICO would be jumping into that.
Yeah.
It would be, the listing agent would have a problem.
Very, very likely. And
well, I'd imagine the buyer probably was pissed off as
And I think the buyer's agent's not too happy.
Yeah.
It just goes to like, when you're throwing in your Schedule A clauses, like we all do this, lawyers do it too. You got your like boilerplate, as we call it. You slap your boilerplate onto every single deal, and then you just kind of, you know, you make like your custom bits, and that's like 10%, and then the boilerplate's like the 80%, 90%.
Yeah.
So just always worth a read of your boilerplate real quick before, if you can. I know it's high pressure and time is of the essence and all that fun stuff, but you
And
could
think
be
about
hurting
the
yourself.
scenario, right? Like think about what, like try and like, you know, where is this going? What am I doing? What is my current objective in this deal, right? And then make sure it's there.
What is the client's objective? Like, why does the client want this property? Right?
Yeah.
In that case, who knows if the agent was even told that the potential laneway mattered so much to this client. But if the agent did know that, oh, the potential for laneway kind of perked my client's interest or whatever, probably worth taking out my zoning boilerplate that I threw into Schedule A, because that kind of shot himself in the foot at the end.
But this potential laneway was completely rejected, or just because sometimes that's a commit of adjustment, whatever, that's not exactly
No,
what they
this
want,
was-
but you
this
can
was-
build something smaller,
The
or.
only way for this to be built was not a committee of adjustments application. This was a complete redo of the bylaw,
Yeah.
which you can't do through committee of adjustments. Committee of adjustments can do
Yeah, only just the
zoning
10%.
applications, right? So if the zoning doesn't permit for 2 units, you could potentially get 2 units if you get a committee of adjustments that agrees to it, or a setback issue or something like that, right? Like you want to build a house, but it's too close to the front yard.
Fire access, whatever.
Whatever. Zoning stuff you can do through committee adjustments. Bylaws, you can't do through committee adjustments. You actually have to get the city council to amend the bylaw completely, which is like, you're not doing it. You're like,
2 years.
not for this little small garage laneway development, right? So, and the bylaw for laneway developments it's a bylaw, not a zoning thing. And so that's why there was like specific requirements in the bylaw that says it's gotta be X width and setback requirements and all that other stuff. And I think it was off by like 6 inches, and the buyer, or our client, did look into it and talk to the city and said that if the foundation of the house, it's an old, you know those old Toronto homes that have the stone foundations that are like 1.5 foot thick. They said if they did underpinning and they redid the one foundation along the one side and made it skinnier by 6 inches, it would fall within that development. But they weren't smart enough to like go off to the city and ask that. They just like, let's sue them, right? Like we want to get out of this deal. And I mean, they might now that they're the owners of the property, they might try and figure out how to do it. But that was one of the ways that they could have gone around it. And I've had a lot of fun ones this month. I still have one that's been going on since, I don't know, since May. And that one we kind of, it was like a flurry of like extensions, one after another. They bought a property. It was a mortgage broker that was buying their home. They couldn't close. That basically just completely went MIA on us on the day of closing. Didn't even hire a lawyer. Just didn't even bother. Just like signed a deal and never even like showed up to the table. What we did on that one was we actually agreed for the seller, the people that we were buying from, to relist their property in the meantime while we were trying to also resell our property. And that went on for 2 months, and they ended up getting a deal with, so the people that we were buying from ended up selling their property for $100,000 less. They offered our client a $75,000 offer to basically settle. Our client, I tried to reason that these were unreasonable people, which would have been, I think, beneficial for them to have agreed to that. Granted, they probably didn't have the money. I don't know. Maybe that's one of the reasons why they didn't do it. But so now they're being sued by those people for the $100,000. They got to then go and sue the people that caused the whole problem, which was the person that bought from them. And their like damages are like close to $200,000 at this point with legal fees and everything. could have walked away with probably 70 grand in damages only.
Yeah.
Because the other buyer had a $100,000 deposit that they're going to get that 100,000 back, but they could have reduced their damages a bit. But
Yeah, it just goes back to the point of dealing with it early is harder for clients, but usually ends up with a better result from, you know, which is easy for us to say because we're kind of 30,000, you know, meters up in the sky looking down and just looking at numbers with hopefully with pretty much no emotion, but and our clients are the opposite, where they're just full of emotion and having trouble seeing things as just numbers. But
it really depends on the individual that you're dealing with, honestly. Like, it's their personality takes into effect, and you know, they're either reasonable people and they are able to think things through, or they're not and they're just all in emotion and principle. And I think principle needs to be taken away from the equation completely, because what's right and wrong doesn't really apply so much sometimes. Like, what you think is right and wrong. You know, the law is set up in such a way as like a general overall encompassing right or wrong, not your right and wrong. Right, so.
gotta love when lawyers tell you that right and wrong doesn't matter.
So you guys are probably seeing a lot of lawsuits, I mean, stuff like this happening now probably. And you're probably seeing a lot of money being rewarded, more or less, or
like
more rewards being granted?
Other than like in the emergency scenarios, not many of them have gotten to the point that they've had any awards that I know of.
Yeah, we're not there yet.
Not
You know,
there
there's
yet.
like a 1 year, 2 year
And
process.
then my next question is how easy, once those awards have been granted, even collecting the money?
It really varies. So going back to things not being fair, it depends who it is you're getting the money from. So like we were mentioned before, if it's a first time home buyer, kind of not great. Like they don't have any assets. Like they, you know, there's nothing to go lean. Like maybe you could try to garnish their wages if it's efficient enough, but it's a nightmare. Like it's not that great. But you know, against the guy who, you know, going back to that scenario I was talking about way back in 2017.
Yeah.
In that scenario, the guy owned a house he was trying to move. So there was a piece of property to go after, which, you know, made everyone much more comfortable. And that was just that scenario was more just trying to make sure he didn't do any family law shenanigans, divorcing his wife or something like that, to try to, you know, reduce how many assets he had and those types of things.
Yeah.
But he recovered because there were assets we could go after.
And then for a first-time home buyer, I mean, you can't really go after, but what about the credits and stuff? Like, I mean, once
You garnish their wages, which is probably like the best you're gonna get.
Yeah.
And
I'm just
garnishing-
asking, you know what I mean? The worst case scenario.
There's something, and to take a step back, there's something called like a writ of execution, which you might hear about every once in a while, like from your real estate lawyer that you're ever talking to, and say, oh, we have a writ issue or something like that. You might hear that. Writs are, if you lose a lawsuit, the plaintiff can file a writ against you with the sheriff. The civil sheriff's just an office of the court.
Yeah.
So every time you get a mortgage, you know, we have to get a writ check against the person. So if you're receiving mortgage money and a writ comes back saying you owe, you know, Bank of Nova Scotia $12,000 for unpaid credit cards, because the banks are really good at getting writs for credit cards, it's getting paid from those mortgage proceeds. So that's, again, these are people who have assets and who are like, even in the scenario with the 2017, after our sheriff was denied because of COVID, we were sitting around waiting for the guy to refinance because we knew his mortgage was coming up in a year, and we're like, okay, fine, we'll let him refinance and we'll ding him then. But all to say, big money transactions tend to need a writ check, but like small bean stuff don't, right? So you're stuck either going after wages if they're never going to be doing other big transactions, but it's gonna, like, going back to your principal view from before, no way you're getting off scot-free. Like your credit is ruined, you have a writ against you, you know, it's not a good situation to be in.
Okay. Again, just what sellers ask us, right? So
Yeah.
we want to be able to give this information when we're advising them, or, you know, saying may not be worth it. But like you said, sometimes people just want to know, what can we really do, and what are the...
No, there's definitely things you can do. You have rights,
Yeah.
but they're expensive to enforce.
Yes.
That's the thing.
And that's why it doesn't
right?
make
So
sense, right?
it's-
So you just gotta...
You know, when you're in a multi-million-dollar deal, it makes sense to hire a lawyer and pay 20, 30 grand.
Yeah.
But when you're dealing with like a $500,000 condo and your deposits are 30,000, like what? You're just wasting money at that point, you know?
Which,
That's where principle kind of goes out the window.
yeah. You know, a lot of litigators, a lot of lawyers, they'll tell you how expensive principal is. Like and judges will tell you too. Like you end up in settlement conferences, and a judge will, you know, sit there and look at the party who seems to have the principal position or whatever and go, are you willing to spend $10,000 on this principal? Like, you're gonna be the one to teach someone a lesson, it's your money. It's not a good use of your money. So, you know, it sounds nasty to go back to right and wrong is not what matters here. What matters is coming out in a good position with the least amount of headache and with the most amount of money as you could have, because it's a crap situation for everyone.
Yeah.
I saw an interesting clause in an offer that I received recently, and I'd never seen this clause before. It essentially said that like between the acceptance of the offer and the closing of the property, that any assessments levied against the unit would be the seller's responsibility within that acceptance and closing period.
Right.
For me, that sounded like if there's an assessment, it takes 2 years for it to go through, they're gonna come after the seller in 2 years for that.
Are we talking about tax assessment or for condo fee?
For condo fee assessment.
Yes.
Yeah.
Probably like a special assessment?
Any
Is
special
what-
assessments, yeah.
Well, they're usually announced and passed, so by the condo board. So it's not so much about like when does it become collectible. The hard part there is just which one of those, in my mind, Ed probably has an opinion too, but which is the clause talking about announced assessments or past assessments? So it might be that the condo board comes forward and says we're going to need to do a special assessment. We just found Kitech running or some disaster, right? Okay, well, does that meet the clause or not? They haven't actually quantified how much it's going to be. It hasn't actually been passed as a special assessment by the board of directors yet. The board is just advising people this is going to happen. Like, it's going to happen at some point. So ideally, and of course, you know, lawyers are always asking you for like these perfect clauses, which are so hard for everyone to do.
But you can get a perfect clause, but you're not going to get your deal done. That's the other problem, right? Like, so you want all this fancy wording in there, but then it's going
You're going to scare everyone away.
scare everyone away. And so it doesn't work.
From our side of things, though, the hard part is like your client is going to think if it's just announced, is going to say, "Well, I wanted that to be part of, you know, what I'm protected from." And obviously, the seller's going to come back and say, "No, that's not what the clause means," and then you're going to have a bit of sorry.
Knowledge of.
Yeah.
The seller has any knowledge of.
Yeah, if they have any knowledge, but again, the wording is going to be super important. So it's just
What they don't know, they
the
can't tell.
wording of the clause is going to be super important to find out, like.
But is it even possible for the buyer to then chase the seller like 2 years down the road and say, hey, there was this period, something was announced, and
Oh, for sure.
like just a
They gotta
general.
prove that it was prior to the closing date.
Yeah.
Right. So if the
But they
announcement,
can come down 2 years.
well,
later.
again, it depends on what the wording is in the agreement and how it's worded. There's a potential for it. It kind of comes back to what we were talking about. Most special assessments typically are less than $5,000.
Yeah.
Typically, for most bigger condos. If it's a small condo, for sure, it might be a bit more because it's less units being spread over. Are you going to sue for $5,000? Probably not.
Yeah.
You're going to spend $10,000 to even just get to that point, right? So.
Is there a statute of limitations for any kind of lawsuit?
Yeah,
Like-
it's 2 years, but typically, you know, you only found out about it when the actual
Right,
assessment was
right.
created, right? So your 2 years start at that point.
Right, I see.
So, you know,
Yeah, your 2-year period typically is going to start when you could have reasonably known about it. So it's not like 2 years from the date it exists. It's 2 years from
And then you know about
where
it,
you could,
okay.
you know, conceive knowledge of it. But my last little comment just on the special assessment thing. If what you're like, what I think you're really asking is like, how could I do that for my client, right? If I was
No, I
No?
thought it was ridiculous. I'm crossing out as it's not happening.
Yeah, that's, which is probably, if you're on the
I've
seller
never seen
side,
it.
that's probably a good thing to do because it's, all of these questions are gonna potentially raise themselves and then it's just gonna end up, everyone's gonna be mad, right? They're gonna think, well,
It's
this.
kind of like the potential wording, like it was
Yeah.
very ambiguous. Like no, it's
yeah,
not.
I hate clauses that create ambiguity because it just creates nothing but problems. On closing, after closing, who's right, who's wrong, like no one knows. Then you gotta go to a judge and you gotta like spend $1,000 to do research on case law and you know, it's like gonna get you nowhere. So you're better off when you see some sort of clause that creates ambiguity to fix it and be very specific as to what needs to be done, or just cross it out completely and say, no, this is like weird. Like, why would I agree to this?
Yeah.
This gets us nowhere, right? So you have, and in a scenario like that, you know, you can say to them, like, you have your status certificate. If you've got questions, call the property manager. they'll direct you as to what potentially could happen.
And it came down to that.
You know, and like, don't get my client involved in that. That's for you guys. That's why you have your due diligence clause there to review your status, talk to whoever you need to talk to, and then figure it out. It's either we're going to this deal or we're not. You know, it's kind of like.
So can we just guys call you if we are stuck with some clauses, and then we're free of charge, you can give us an advice?
We do that. We do that actually fairly frequently. So
That's great.
if,
change your phone number.
we have what I'll probably do is maybe I'll send it to Julio after I get back later today, because I'm scared to say what the email address is, but we have a dedicated email address for realtor questions. I think it's lawyer question at diamond.ca, but let me send it for sure one off the top of my head. But those questions actually go automatically to our system and automatically get pinged to a lawyer to call you back, rather than it just going through the regular channels, because it goes through the regular channels like 48 hours to get back to you typically.
Yeah, one of the
You guys
benefits
need to
with our
fax it.
firm is like we're very tech-centric firm, law firm. I mean, I haven't seen a piece of paper on my desk in like 2 years, probably 3, maybe more. I don't know. But everything gets like auto-assigned to either a lawyer, a clerk, or like, there's things that just goes to who it needs to go. There's based on task skills, and everyone knows what they're doing. And
But if you like Ed more than me, which I'm sure you do, you can always email him directly, or myself, or anyone. But yeah,